Hi, I'm John Corvino. You may have heard of RFRA, or the Religious Freedom Restoration Act. Of course, religious freedom is a core value of our society, but so is equal treatment under the law. And in recent years, RFRAs have become associated with a license to discriminate. So what's up? Well, let's go back to the origin of RFRA. The federal RFRA was passed in 1993 in response to a case where the U.S. Supreme Court ruled against a plaintiff who was fired from his job after ingesting peyote as part of his Native American religious practices. Peyote is a cactus-based hallucinogen. It contains mescaline, which is illegal. And the court basically said, laws are for the common good, and dude, you broke the law. In response, Congress passed RFRA. What RFRA says is that the law cannot burden anyone's exercise of religion unless applying the law to that particular person is the least restrictive means for achieving a compelling government interest. And when laws fail to clear this bar, they're not struck down. Instead, they're just suspended for the particular religious people whom they burden. Now, you can see how this might be a problem, because it starts to look like religious people, but only religious people, can receive a get-out-of-the-law-free card anytime they find laws burdensome. Take the peyote case that prompted RFRA. If peyote is dangerous, it seems like it would be dangerous no matter what your religious beliefs are. And if it's not dangerous, then why do you have to be a Native American religious person in order to use it? Or take the Hobby Lobby case. In 2014, the court ruled that Hobby Lobby, a huge corporation with thousands of employees, did not have to provide insurance coverage that included certain contraceptives like the morning after pill, even though that coverage was mandated by the Affordable Care Act. The court applied RFRA. First, it determined that the law burdened the corporation's exercise of religion. Now, put aside the question of how a corporation that traffics in pipe cleaners and popsicle sticks can exercise religion. Set that aside. What the court said is there is actually a less restrictive means for achieving this compelling government interest. Namely, the government can pay for the contraceptives, or maybe the insurance company can pay for them. But this is a dangerous precedent, because for any government mandate, of course it's going to be less burdensome for the government to pick up the tab than for the business owner to pick up the tab. What about Scientologist business owners who don't want to cover mental health care? Or Jehovah's Witness business owners who don't want to cover blood transfusions? It's a slippery slope. If we offer exemptions in all of these cases, that just shifts the burden to those who don't raise religious objections, not to mention employees who now have to jump through more hoops in order to get their coverage. And that doesn't seem fair. The general problem is that RFRA doesn't do a good job of taking into account third-party burdens. Now, in the Hobby Lobby case, the court said that the decision should have zero effect on the women employees because, after all, someone else could pay. But just because someone else could pay, it doesn't follow that someone else does pay. And because of partisan politics, it was actually a lot harder to replace the women's coverage than it initially seemed. Now, that brings us to the current moment, where a number of states have been trying to pass state-level RFRAs, often with the clear intention of bypassing anti-discrimination law. There are cases where religious people want to cite their religion so that they can refuse to serve or to hire or to provide housing for people whose life choices and identities they disagree with. Notice the contrast here. Some religious liberty claims mainly have to do with the religious believer. Whether you ingest peyote cactus, whether you wear a bikini or a burkini, whether you observe the Sabbath on Saturday or Sunday or not at all, those things mainly affect you. But other religious liberty claims are different. They're not just about leaving people alone to do their own thing. They're about when we come together in commercial spaces and interact with people who don't necessarily share our faith. In that context, granting special religious exemptions from laws designed to promote the common good can effectively impose your religious beliefs on others. And that's not religious liberty. That's religious privilege.